Hello, everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers. If you are tuning in on whatever platform you're tuning in on, if you're tuning in British Columbia, Alberta, or Ontario, in the provinces, of course, in Canada, then go ahead and feel free. This is your time. This is your chance to go ahead and speak with an employment lawyer. Get your questions answered. If you're dealing with a situation at work, again, we're talking about employment law here. If you're dealing with any kind of situation at work, really, if maybe you're being mistreated at work by a colleague or a boss, certainly, if you're being punished unfairly for whatever reason, certainly you have rights as an employee in those kinds of circumstances. Certainly, if you've been temporarily laid off of your employment, if your employer is trying to change your terms of employment, maybe they're asking you to accept a different schedule. Perhaps they're asking you to accept a demotion or some sort of pay reduction or a change to your bonus plan. Certainly, I mean, these are critical areas where you need employment law advice. You don't have to accept a negative change to the terms of your employment. It's what we call a constructive dismissal. And as well, of course, if you're dealing with a termination of employment, if you've been sat down by your employer and told it's not working out, or you're told that your position no longer exists, or the company is cutting its budget and downsizing, and your job is eliminated as a result of that, really, whatever the reason for termination is, that is, again, a critical situation before you sign anything that your employer offers you. No matter what the amount of money is, it may be a 5-figure number, it may be a 6-figure number, whatever the amount of money is on the paper in terms of a severance offer, do not sign on the spot. Do not sign based on what your employer is telling you to do. If they're telling you to sign or forcing you to sign, make sure, please make sure that you speak with an employment lawyer before you sign off on any kind of severance offer. We see it day in and day out. I kid you not. We see it every single day of the week and every single week of the year. We see severance offers that are far too low as compared to what employees are actually owed when it comes to their full severance entitlements. Keeping in mind, and I'm sure we'll get to through this over the course of the live stream, keeping in mind, of course, that severance is based on an employee's age, position, and years of service. The longer you're with the same employer, the older you are, the more senior or specialized even your position is, the more severance you're going to get. Severance, everyone, could be as much as 24 months, not weeks, 24 months of pay. That's 2 years of pay. That is generally the maximum amount of severance that any employee is going to be owed. And again, the point here is not that everybody is going to be owed 24 months. Obviously not. That's the upper end of the range. But it is that the severance offers that we see from employers time and time again is far less than what those employees are actually owed. And the good news there is it's actually very easy, not complicated at all, to reasonably increase an employer's severance offer to within the appropriate range. But again, before you try and negotiate, before you say yay or nay to any kind of severance offer, please make sure you speak with an employment lawyer. You can obviously contact us, and I'll share our contact information in a sec. If you don't want to speak to us, go ahead and speak to another employment lawyer. By all means, just make sure that you're speaking with an expert and a professional in the field of employment law before you make any kind of decision when it comes to your employment. Employees in Canada, generally speaking, and I'll speak for Ontario more specifically, it's the province that I practice in, but generally speaking, our employment laws in Canada are very protective of employees, very protective of their rights when it comes to severance, certainly, but also when it comes to things like changes to your employment and when it comes to things like bullying and harassment in the workplace. I highlight those points because they are the most common issues that employees face in the workplace, and they are also the most significant because, again, severance, whether it's by means of constructive dismissal or an actual out-and-out termination, your severance entitlements as an employee are going to be significant, even if you're a short-term employee, even if you've been with the same employer for 6 months or a year and a half or 2 years, your severance entitlements could still be several months of pay. And again, if you're in a well-paying job, you're in a specialized position, then that severance is going to be significant. Okay, I mentioned that we'd share our contact info If you are dealing with a situation at work, maybe you're a little bit too shy or bashful to talk about it on a live stream here, whichever platform you're viewing this on, please go ahead and contact us. I promise we will get back to you. The first thing you should probably do is visit our website. You see it on the screen right now. Employmentlawyer.ca is where you can find, number one, all of our contact information in terms of our various offices across the country, in terms of each individual lawyer's contact information if you're looking for somebody specific, but also, quite importantly, we've got a ton of resources on our website. Ton of articles, ton of news clips, video clips. We do lots of interviews in the public and in the media, explaining various issues that are in the news when it comes to the world of the workplace and employment law. So go ahead, and we have tons of primers as well in terms of the basics of severance, the basics of temporary layoffs, etc. Go ahead and visit our website. It's a great resource if you want to get your feet wet in terms of the kind of workplace situation, the kind of employment law situation that you might be dealing with. You can also email us, of course. Our email address is very straightforward. It's help@employmentlawyer.ca. Again, it's on the screen right now. Go ahead and send us an email at help@employmentlawyer.ca. Give us a brief description of the situation that you're dealing with, and I promise someone will get back to you. We have a team of intake personnel standing by to field phone calls and field emails and field questions from the general public, and most importantly, to put you in touch with one of our employment lawyers or even paralegals, perhaps, if a paralegal is more appropriate for your particular circumstances. Once again, for those of you just tuning in, my name is Alex Lucifero. This is an employment law live Q&A. If you have questions about your workplace, if you have questions, really anything under the sun that deals with the world of your employment, of employment law. You could be an HR professional, you could be an owner of a business, you could be, of course, an employee as well. And by the way, you could even be a contractor. Yes, that's right. Independent contractors or dependent contractors have rights, have protections. A lot of times they have the same exact protections that regular employees have because they're actually, in fact, employees and not contractors. If you're in those situations and you're wondering about, maybe you've got an issue about your pension, maybe you've got a question about whether your employer is allowed to do this or not allowed to do this, maybe it's about vacation pay or it's about your wages, overtime pay is an issue that comes up more often than not. And again, certainly things like severance. Please, by all means, go ahead and post your question right now on whatever platform you're viewing this on. Keep it confidential, of course. You don't have to mention your employer's name. You don't have to provide any personal confidential information. Keep it general, keep it brief, and I promise I will get to your question before the segments end. I make it a point actually to get to all of the questions, and sometimes we go a little over our allotted schedule here to make sure those questions are answered. In terms of contact information, I wanted to share our phone number as well. Again, if you're in Ontario, Alberta, or British Columbia, and you're dealing with a situation at work, and maybe you're a little old school, you like to pick up the phone and give us a call. Absolutely no problem at all. We've got a toll-free 1-855 number. It's on the screen right now. Make a note of it. Give us a call. If we don't pick up because perhaps lines are busy, go ahead and leave us a detailed voicemail. Make sure to leave your phone number, leave your full name. Again, give us a 30-second or a 1-minute description of the situation that you're dealing with. And again, I promise, I assure you, someone will get back to you. Okay, let's get the show up and running, folks. I typically we usually do the radio show in Toronto on Monday nights. That's why I call this the show. Of course, this is a live Q&A. And by the way, if you're dealing with a medical leave of absence, let's say you're dealing with an illness or you're dealing with an injury, that injury could have happened at work, it could have happened outside of the workplace, and you've had to take some time off. Maybe you've had to apply for disability insurance. Maybe you're doing that through your employer. Maybe you're doing it with a private disability insurance company. If you have issues dealing with a medical leave of absence at work, maybe your employer is giving you a hard time, asking too many questions, bothering you a little too much when you're taking time to rehabilitate and to get better. Or if the insurance company, by the way, is giving you a hard time, maybe they've denied you disability insurance benefits despite your doctor filling in the application. Please go ahead and post a question as well. That's part of the world of employment law, at least in part, and we have an entire department of disability insurance lawyers that deal with insurance companies and make sure that employees get the proper compensation that they are owed when they are medically unable to work. Disability insurance as well, particularly for longer medical leaves of absence, for more serious illnesses and injuries. Disability insurance could be very, very significant. Don't just take the insurance company's word for it if they deny your claim. Don't just take your employer's word for it if they're asking you to do this, that, and the other if you're on a medical leave of absence. Employees, again, are very, very well protected when they are on medical leave. Again, if you're dealing with those kinds of situations as well, don't be shy to reach out. We are more than happy to help and more than certainly capable of helping in those kinds of situations. All right, I was mentioning our radio show. On the radio show, we typically do a segment called The Case of the Day. It's an opportunity to talk about a matter that came across our desk that day. I will talk about something that's actually, we've been fielding a ton of questions, emails, phone calls to our offices about this, and I wanted to mention it on the live stream today in case, and I suspect there will be a couple of people listening in that are either in this exact situation or dealing with a similar situation. The situation I'm talking about is in Canada, the Hudson's Bay Company, the Bay, has effectively decided that it is closing all but, I believe it's 6 locations. And so they are effectively shutting down, ceasing operations. And we've received a ton of calls and emails from employees asking, what are my rights in the circumstances? Am I owed severance if the company is shutting down? What can I do here as an employee to make sure that I'm protected? Some of these employees, by the way, they've given 25, 30, 35 years to the Bay. They've worked there their entire careers, in essence, and they are now being let go, being told that the company is shutting down and that their location is shutting down. And I guess I have a mixed bag of news here, unfortunately, and I'll start with the bad news. The bad news is this: the Hudson's Bay Company has effectively claimed bankruptcy. Bankruptcy is, in essence, a worst case scenario for employees of any company, whether it's the Bay or any other company for that matter. If an employer is going into receivership or claiming bankruptcy, those two things are effectively the same thing. Again, that is bad news for employees because essentially they become creditors. They become a creditor, an unsecured creditor of the company, like anyone else that that company owes money to, other than the big banks, perhaps, where they'll have their loans and whatnot secured by property, most likely. But as an employees or any other clients or customers of the company, they will become unsecured creditors. And what that means as an employee is that even if you are owed severance, which you are, of course, you may receive cents on the dollar as compared to what you are actually owed. You are not likely to receive your full severance entitlements in a situation where a company goes bankrupt. It's actually, I'm trying to think here. I've practiced employment law for many years now. It is probably the only situation in which an employee is let go without cause, of course, meaning it's due to no reason of their own and is not going to be owed severance. Bankruptcy is one of those, if not the only exception to the rule that when an employee is let go, they are owed severance. And so for those employees who've been let go or are going to be let go by the Hudson's Bay Company, unfortunately, your severance entitlements are going to be limited. They're going to be minimal. Certainly, if you are a unionized employee of the Bay, you should speak with your union, speak with your union rep, make sure that you are up to date on what the union is doing for you. Remember, as a unionized employee, your legal representation is your union. You cannot necessarily speak to an employment lawyer yourself individually as a unionized employee. It is your union that effectively represents you legally through the union and to the company. And so it's going to be your union that's going to be taking on the challenge of trying to get some severance out of the company. If you are a non-unionized employee, then you should certainly speak with an employment lawyer if you have any questions or concerns. But again, when it comes to severance and bankruptcy, odds are your severance entitlements are not going to be your full entitlements. They're going to be limited specifically because of that bankruptcy. The good news, and it's a sliver of good news, but it is good news. If you were working for an employer that was, let's say, affiliated to the Bay, let's say you were working in a cosmetics department and you worked for one of the other companies, I'll give you an example, the makeup company MAC. If you were working for MAC, for example, or any other company within the Bay, but on your paycheck, it doesn't say the Bay, your paycheck says MAC Cosmetics, or it says any, whatever the other name of that company is that was working at a kiosk, for example, within the Bay, well, then you don't, that bankruptcy doesn't apply to you. You're an employee in that, using that example of MAC Cosmetics, in which case MAC isn't going bankrupt here. Right? So that doesn't apply to you. So if you are let go because of the closures, but your employer isn't the Bay, it's another entity, right? Then that bankruptcy does not apply to you. You would still be owed severance, and severance based on your age, position, and years of service, and you would be owed absolutely every single cent of what your full severance entitlements are, if your paycheck and if your pay stub and your T4 and your employment contract, you were formally employed directly by the Bay. I hate to say it, but that's going to be a difficult situation for you. I wanted to talk about it today because, again, we're fielding a ton of calls and questions about it online. I hope to a degree I've set the record straight in that respect. But again, if you're in a different situation or a particular situation, again, maybe you're on a medical leave of absence with the Bay and you're not sure how to handle that situation, my advice, and the best advice I could give you, would be, don't be shy to reach out to us. Let's have a conversation off live stream, off air, write a confidential private one where we can get into the details of your specific situation and you can get tailored specific advice from an employment lawyer. And be wary of bankruptcies. And as a last point here, I also want to be clear that there is a difference between a company going bankrupt and a company closing shop or ceasing operations. A company can cease operations and say, you know what, we're shutting up the business, we're no longer going to be operating here, but not claim bankruptcy. There can actually be a lot of revenue being generated by that company that's deciding to cease operations. And it makes that decision for a number of reasons. It could be any reason, really, but there could be plenty of money there such that they're not claiming bankruptcy. As long as the company doesn't claim bankruptcy, an employee is owed severance. There's going to be no question about that, even if the company is ceasing operations. In the Bay's case, unfortunately, they are ceasing operations. They're also going into bankruptcy. And that is the nail in the coffin, I hate to say, for a lot of employees who would be hoping for severance and hoping to receive their full entitlements. And unfortunately, that bankruptcy creates a problem in that respect. All right, for those of you waiting for your questions to be answered, thank you for your patience. I wanted to get through that. It's important to get through that kind of information. Again, lots of people out there asking for that information. Let's go ahead and get rolling with the questions. I think we've lined up quite a good amount here. So thank you, all of you who have already posted your questions online. Again, if you're just tuning in, this is a live employment law Q&A. Go ahead and post your question. Don't be shy. Feel free. This is your chance to speak with an employment lawyer to get you headed in the direction of solving your workplace problem, whatever that problem is. Whatever the situation that's keeping you awake at night or causing you stress and anxiety throughout the day, there are answers to your questions. There are solutions to really any workplace problems. A lot of times, the solutions are straightforward. They're actually quite practical and quite easy to implement. Whether it's during the course of your employment or even having been let go from your job, there are solutions everywhere. But of course, the law can't help you if you don't know what the law is and you don't know the way the law works. And again, that's what employment lawyers are for. They're here to inform you on what your rights are, and also inform you on what your obligations are, of course, as an employee, and then to provide practical, straightforward solutions and options that you can then implement, and a lot of times with the help of that employment lawyer. Speaking of which, let's get to applying some of that right now. First up on YouTube is Wed1234 asks, my cousin works at a dental clinic in Ontario. For the past month, her employer said she could work at another of the office to get more hours. She's been consistently working overtime, but her employer has been paying her 2 different paychecks because the work is being done at 2 different offices. Thus, she isn't getting paid overtime. Should she file a complaint? Great question. if this is effectively the same employer, and I don't care about the locations, by the way, of the offices, right? It could be, one office on Main Street and one office on another street. If it's the same employer, that pay is being earned from one source. And of course, if that employee is working more than 44 hours a week in Ontario, they should be receiving overtime, which of course is time and a half's pay for any hour worked above and beyond that 44 hours. It doesn't matter what location you're working in. If it's for the same employer, then that overtime pay is going to be owed. There's no question about it. And WED 1234, actually, your cousin could go back in time if there's any missed overtime pay and claim all of the overtime that she might have missed. So make sure she's keeping track of all of those hours very, very carefully. I will make one last point here. And because the WED 1234 here asks, should she file a complaint? Now, when I hear the word complaint, I think of a Ministry of Labor complaint, because that's what the language that is used in Ontario. And it raises a good point here that needs to be made. When we are talking about issues like overtime pay, like vacation pay, unpaid wages, holiday pay, statutory holiday pay, for example, if you don't feel like you're being paid the right amount of vacation pay or holiday pay or overtime pay, such as the case here, I actually don't mind an employee going straight to the Ministry of Labor, give them a call, speak to them. They'll likely tell you to file a formal complaint and process that kind of overtime pay or vacation pay or holiday pay issue through the Ministry of Labor. The Ministry of Labor is actually quite good at investigating those kinds of complaints. But what I will add to that, and this might be the more important advice here, is if you're dealing with a severance claim, if you've been let go from your job, maybe you've been let go for cause or alleged cause and you haven't been offered any severance. Or maybe you've been let go without cause and you've been made some sort of severance offer and you're suspicious that it might not be enough. By all means, please, please, please do not, and I repeat, do not go to the Ministry of Labor when dealing with severance or dealing with things, for example, like temporary layoffs or changes to your employment. The Ministry of Labor cannot advise you on what your full severance entitlements are. The analysis of severance being based on age, position, and years of service. And severance being as much as 24 months of pay, 2 years of pay. It's not a fictitious number. That is an accurate number, particularly for longer service employees, more senior employees. Ministry of Labor can't get you that kind of severance. They can only enforce an employee's minimum statutory entitlements. That's why they're good at things like overtime pay and vacation pay. They're not good at things like severance. If you have a severance issue, if you've been let go from your job, do not go to the Ministry of Labor. Please contact an employment lawyer. An employment lawyer, and ultimately our courts in Ontario, can enforce your full severance entitlements. The Ministry of Labor cannot. Next up is Quant Guru. Quant Guru asks, is 4 weeks of severance fair under Ontario's common law for someone with my profile? 2 years tenure, 10 years total experience, professional designation, a CPA, mid-level management role, 38 years old, and with a newborn. Congrats, by the way, Quant Guru. No warning, no PIP. PIP is a performance improvement plan for those that don't know. There was one write-up in 2024. Quant Guru, easy answer to this question. 4 weeks of pay is not enough based on the common law, or what we call an employee's full severance entitlements. 4 weeks of severance is nowhere near enough for a 2-year employee who is a professional, chartered professional accountant and 38 years of age. The newborn may or may not play a role, Quantum Guru, in the calculation of your severance entitlements. But listen, 2 years of employment, 38 years old, CPA, your severance entitlements can easily be in the range of 3 to 5 months, Quantum Guru. So 4 weeks or 1 month is nowhere near enough when it comes to your severance entitlements. Quant Guru, give us a call at the office, send us an email. You can contact our general line. You could contact us directly, whichever you prefer. Don't sign anything before you speak with one of our employment lawyers. I'd want to review your employment contract, the contract you signed with the company. That may play a role in your severance entitlements. It may not either, but we want to make sure one way or the other. But 4 weeks is not acceptable as an initial impression. Even as only a 2-year employee, even being quite young and early on in your career at 38 years old, 4 weeks for a 2-year manager is nowhere near enough when it comes to an employee severance entitlements. Again, severance is significant for employees based on their age, position, and years of service. All right, don't be shy to reach out to us, Guru. It sounds like we need to have a conversation. Tarabal T asks, I'm back with a question for my sister-in-law. Welcome back. If she has a medical complication due to childbirth and has to go on disability leave, should she wait for her leave time to finish? Good question. As a practical matter, Tarabal, I would get that application for disability benefits and disability leave up and running right away. Your employer may tell you, okay, well, maybe disability benefits will only start once your leave has formally ended. There may be a timing issue there, but I would not wait for the sake of waiting. I would file whatever paperwork, whatever material, whatever doctor's letter or form that you have to complete to take a medical leave of absence and to then apply for disability benefits. I would move on that right away. Is she eligible for long-term disability benefits while on maternity leave? It depends what she's receiving, Terrible T, while on maternity leave. If there is income flowing there, for example, employment insurance, right? Or maybe her employer has some sort of policy whereby she is paid a certain amount while on maternity leave. Well, there will be a set off there with LTD. So she may receive a certain amount. There may be an amount received from the disability insurance company, an amount received from her employer or from EI even. Again, there's going to be a set off there, but I wouldn't let that cause a delay either. Get the medical note, speak with your doctor, make sure you have support from your doctor in confirming that, yes, you're currently on medical leave, or you should be taking a medical leave of absence, and then speak to your employer about it. All right, Samuel is up next. Samuel asks, what is the best method to deal with a bully in the workplace? Great question. It's very much a situation at my work, and I feel very unsure how to move forward. Samuel, excellent question. Another question that we get day in and day out. This is an unfortunate reality of many workplaces nowadays, whether it's a boss or whether it's a colleague, just employees being treated poorly at work. A lot of times being berated and belittled and spoken down to at work, and it's simply unprofessional and inappropriate. Some managers will take work away from employees because they don't like them, and that affects their income. If you're on commissions or on bonuses as part of your employment, and the work that you're being given is being limited because someone may not have taken a liking to you, that's a problem, especially if it's affecting your income. Samuel, here is how I would handle it. Number one, you've got to speak with somebody internally within the company. You've got to speak to HR. You've got to speak to one of your bosses. Try and find an ally within the company. And by ally, I don't mean somebody that is going to agree with every single thing that you say is going to take your word as gospel and do whatever you tell them to do. That's not how it works. You need to be reasonable, practical, realistic here. But when I say ally, I mean someone that will actually listen. Someone that will actually, and by the way, employers have a legal obligation to investigate these kind of matters, to look into it. Speak to the colleague that's bullying you at work or the manager that's bullying you at work, trying to find a solution internally. How do we solve this problem, right? Does somebody need to be reprimanded and told, hey, you shouldn't be speaking to others that way? Sometimes it's simply a personality conflict, and areas of work need to be delineated a little bit better, and perhaps these two employees shouldn't be interacting all that much. That's another potential solution. And a lot of times it is human resources, it is HR, or even a manager, if not HR, that will come in and act as a mediator, essentially, to try and resolve the dispute. Now, Samuel, if that doesn't work, and I hate to say it, but oftentimes it doesn't work, HR is often there to simply protect the company and not much more than that. That's when then you have to have a discussion with an employment lawyer. Because if the bullying has reached the point where it's severe, and by severe, to be clear, it doesn't need to reach the point that it's physical or confrontational. It could be verbal only, and it could be relatively subtle. But if it's reached the point that it's severe enough, that is when you as an employee could stand up for your rights and say, hey, either you solve this problem or I'm going to claim constructive dismissal, meaning I'm going to consider my employment at an end because you, the company, didn't do anything about this situation and still seek my severance entitlements. Before you mention the phrase constructive dismissal to your employer, before you threaten to quit, and by the way, you should never be quitting your employment under duress, right, or because your employer has done something without speaking to an employment lawyer. Before you do any of that, get advice first. Let's strategize. Let's brainstorm first. Figure out what your best option is, and then you can implement that option. Don't jump the gun, make the decision, quit, or ask for severance, and then have to speak to an employment lawyer. You're doing it backwards if you do it that way. All right, a couple of more questions. We're going to go a couple of minutes over time, if that's okay with everyone, and get to these last couple of questions. Steve, I see you there, and Yasir, or actually Art is up next. Art says, work for a small financial planning firm. The owner is retiring and selling off. I am an admin. What should I expect when it gets sold? Will I have a job? Am I owed anything if not? Art, great question. Easy question to answer. If your employment continues with the new owner, right, and seamlessly from day one to day two, or from old owner to new owner, your employment simply continues. Well, then all of those previous years of service continue to count. By the way, you don't start as a day one employee with the new owner, right? And your employment simply continues. Be careful about any employment contract that you're offered. Make sure you speak with an employment lawyer first. Those employment contracts could be very tricky, and employers could take advantage of employees when they're being offered employment in the context of a sale of a business. So be careful. Don't sign anything in terms of a new employment contract without speaking with an employment lawyer. If, Art, however, your employment ends with the old employer and the new employer doesn't take you on, you are 100% owed severance in a situation like that. It's a normal termination of employment. You're owed severance, Art, from the old employer, if the old employer is the employer that let you go. If the new employer doesn't decide to hire you and you never work a day with them, then the old owner owes you severance, and your severance is going to be based, guess what, on your age, position, and years of service. And it's probably going to be significant if you've been there for a while. All right, Yasir asks, are the contract employees entitled to employment insurance after the completion of the contract? Yasir, yes, you are. If you've been paying into EI, employment insurance, then you would be owed employment insurance. If you're being paid as a contractor, however, and you haven't been paying income tax or EI or CPP, well, that might be a problem. So it depends on whether you've paid into it or not. If you've been paying into it during your contract, then yes, you are owed employment insurance. Steve is up next. Steve asks a couple of questions. Steve, I'll try and get to at least the main ones. Steve asks, I am currently suffering and undergoing diagnosis for a neurological impairment that impacts my ability to move. How do I handle disclosure to my employer? Do I have to? Should I? Steve, you should. You have to advise your employer that you are dealing with a medical issue and you're unable to work. Your doctor, by the way, will know how to handle this. They don't have to know what the diagnosis is, Steve. It sounds like you might not even know what the diagnosis is. They don't have to know the gory details, if we can call them that. They don't need to know everything about the illness that you're dealing with. They need to know, A, that you're not able to work, and B, that they're figuring out, that your doctor is investigating what the prognosis might be like. How long might you be out for? At the moment, right, you can be off indefinitely, and your employer has to respect that. So you can share actually very little information with them. Steve, don't feel compelled to tell them exactly what it is you're dealing with, especially if there is no diagnosis yet. But again, there's no legal obligation to tell them what you've been diagnosed with. They just need to know from your doctor, not from you. They need a doctor's letter saying, Steve's medically unable to work, and we'll let you know as soon as we have a better idea of what the prognosis is. You asked, Steve, if you're let go, would you be able to negotiate a severance package that includes benefits to the age of 80? Steve, benefits are tied to the length of the severance period. So if your severance entitlements are, for example, a year's pay, then your benefits would continue for a year. If your severance entitlements are 2 years of pay, then your benefits will continue for 2 years. Depending on how old you are, continuing those benefits to the age of 80 might be a stretch, unless you're currently 78 and have been with the company for a while. By all means, Steve, feel free to contact us. Let's have a chat off air. Sounds like a pretty serious situation. I'm sorry that you're dealing with it, but you need somebody in your corner that's properly advising you on what you should and shouldn't be doing, particularly when it comes to your employer. perhaps as well when it comes to the insurance company, if you're dealing with disability insurance. That is what we are here for. Thank you all so much for tuning in today. You've asked some excellent questions. Please keep it up. We've got another live stream coming through tomorrow, if I understand correctly. If we didn't get to your question today, or you weren't prepared to ask that question today, do be sure to tune in tomorrow and ask it. Until then, everyone, have yourselves a great rest of the day.